So I guess my first question to you is, how do you get ahead of the difficult judge?
When I get to talk to young associates or law students about difficult judges, I always start with the proposition that it's not my personal opinion that every judge is difficult. I think, in fact, many judges are, if they practiced, especially in the areas you practice in, they seem to be they work with you. But it's my belief that you can make a judge difficult. And the process of keeping a difficult judge from interfering with your client relationship and the outcome of your case is probably starts long before the trial. I know we're talking about trials today, but you have to keep in mind that, and I have just a bullet point list of things like scheduling, decorum, preparation, compliance, competence, those things that happen leading up to the pretrial conference. If you do a good job there, a typically difficult judge will be much better for you.
The judge has a lot of power, so when is this problem really going to rear its head?
You need to know your judge. And I know the clients here that decide to take cases to trial, one of our biggest jobs as trial lawyers is making sure the house we're going into. You know, like you said, Rich, it's like your mother-in-law's living room. Whatever has to happen there, that's the way it's going to be. Certain things you can do, certain things you can't do. And if you don't take the time to know the room you're in, you're going to run into trouble.
So you have a difficult road to walk when you're in a courtroom, right? Because you have presumably a group of people in the box that you have to impress and sway your way. And you have the person that probably has the most sway over the flow of the trial that, let's just suppose, is being difficult. How do you walk that tightrope?
But what I like about being a defense lawyer is, for the most part, the plaintiff goes first. And you get to see what the plaintiff does. And I think, to make it really simple on yourself, the first thing you do is see where the plaintiff lawyer makes mistakes and see what the judge doesn't like about what the plaintiff lawyer did. And if you can treat yourself to not make that same mistake, you will have won that lawyer v. lawyer battle, and the jury, in my perception, will think that you are a better lawyer and you're better prepared. Even though you may have had the same plan with the same document or the same piece of evidence, when the lawyer that somewhere in the case does that first and you see the judge doesn't like it, don't make that cardinal sin of doing the same thing that you should have known if you were paying attention is going to make the judge mad.